So Josh, what I wanted to do today is have a conversation about some of the quite common pitfalls that we come across, particularly when we are acting for an investor that's potentially looking at investing in a corporate, or the other side of that, which is a corporate preparing for investment by an investor. There's a few sort of common themes that we sometimes see, thematic points that we quite often see when we're doing due diligence. And these are things that are almost that stitch in time to get right at the beginning, to then hopefully ensure that it's a smoother process. Particularly when you're looking into a transaction, you're actually looking at that investment coming through. So there's a few that I sort of want to spell out and sort of happy to discuss as we go along. I think the first one that we see generally for businesses is ownership of business critical IP. And I think you quite often see this as being just relevant when it's an IP business, and that's not the case really. It can often fall in, do you own your domain name? And when I say you, I mean the actual corporate, rather than it sitting in the name of an employee or an IT consultant that's sort of perhaps coming for an ad hoc piece of work. So that's the first thing I'd say about actually making sure that the business owns its IP. And the sort of the secondary point in that as well is, if you have any employees that are designing IP or sort of doing ongoing works as part of their employment, making sure that their employment contracts actually reflect that any work that they produce is owned by their employer rather than them personally.
I think that's a really good point about the sort of non-core IP. I've seen sort of multiple deals which, whilst they don't fall over as a result of those items, they've become more protracted and more expensive because things like, as you said, website ownership, trademarks, etc., that they need to be rectified and tidied up. And so while those aren't sort of deal-breaking issues, they have caused sort of increased costs and time consumed a lot along the way.
Yeah, absolutely, particularly when you're trying to then, let's use the example of that domain name that potentially is still owned by a consultant, trying to track down that consultant a few years later to ask them to assign it back to the company can just add an unnecessary complexity to a transaction.
Yeah.
A few other sort of points on the more corporate perspective, and some of this might sort of fall into general admin and housekeeping, but when it comes to the ownership of the business and the ownership of the shares, the one thing that's actually key is the share register and the register of member, which may sit in a hard copy of a set of statutory books. My first thing would almost be to a company to make sure that they hold that and that the names in the book are kept up to date. As I said, it's quite often that incorporation agents, they may not necessarily pass on the hard copy of that book, and quite often it's not necessarily kept up to date with ownership. So I'd say that's another easy one to sort of keep doing as you go along, rather than it be a much bigger task to rectify at a point in the transaction.
Yeah, and that's an increasing issue, despite being an easy one. I think in a more online world, people sort of overlook, and forgivably, most likely, the need to sort of keep the statutory books, which are an offline, quite often hard copy document, up to date.
Yeah, absolutely. I think another point that I think is really key is actually your relationship and how that's governed, particularly if you've got a founding team or multiple shareholders. We would always recommend that a company has a robust shareholders agreement and a robust set of articles of association, with your articles being effectively the constitution of the company and the shareholders agreement being quite a private agreement between the relevant shareholders. It sounds a little bit doom and gloom, but actually it's a case of, do you have all the provisions in that shareholders agreement in case either relationships disintegrate or if something happens to one of your founding shareholders? I said very doom and gloom, but if you have a founder that dies, then a shareholding agreement can provide provisions for what happens then, rather than it almost being a position where it goes to the estate and then the complexity of trying to sort of extract that shareholding from an estate.
Yeah, I think that's where your stitch in time analogy is really true, because We've all seen companies where that cost has been saved at the outset, but subsequently there's an event, either a death or a falling out amongst the shareholders, which doesn't have the right mechanism in place to resolve that dispute. And a good shareholders agreement that was well drafted would have, in that scenario, paid for itself. And I can understand the mindset of many business owners at an early stage not wanting to spend money on something that doesn't lead to an immediate return. But those documents can pay for themselves, sort of, should that doomsday scenario occur, which, whilst unlikely, these things do happen.
Yeah, and particularly, it is that kind of really, you don't want to think about it, but it's also can deal with things like spousal transfers and sort of transfers of shares to family members, and what happens in, again, very doom and gloom, but sort of in any disintegration of any relationships there, what should happen to those shares. A few other points that I know we're going to come on to talk about, but also governs drag and tag and leaver provisions. And almost, if you have a shareholder that potentially might want to exit in the future, what provisions do you want to build in now for equality for all shareholders? The other one that I'd say is quite another common pitfall that we come across is what's called a buyback of shares, which is effectively when, using the example of you have a shareholder who leaves the business, if the company is able to do so, it can buy back the shares from that shareholder. However, that's a really complicated legal procedure to do, and it's really important it's done right, because if it isn't done right, it's void, which means that if you've got a transaction, you can have a position where you're trying to track down a previous shareholder who you might think is no longer a shareholder, but because that documentation hasn't been done properly, they technically are still a shareholder. So that's a real big one that we quite often see being a bit of a pain when it comes to diligence in a company to rectify that situation. Yeah,
and I mean, it's fair to say that none of this is very exciting or glamorous stuff in the early stages, but it can save it can save a lot of legal fees in the long run, having all this stuff right and in the bottom drawer ready to go when needed.
The more, I guess, thinking about it, the trading part of it is the importance of getting your commercial contracts and arrangements right from the get-go. So there's a few things. I mean, obviously, ideally, an entity would contract on its own T's and C's that it's comfortable with, having a solicitor looked at them. But obviously, I appreciate this is not always going to be practical, particularly when you may well be contracting with an entity that's much bigger than you. So a few points that I'd sort of recommend that a company's mindful of when it comes to contracting on someone else's terms. That's whether the pricing and payment provisions set out in the contract are actually what you're expecting to be. The second thing is, are there any currency fluctuations? If so, who takes the responsibility for those hedging fluctuations? Indemnities generally should be approached with caution, because that's sort of potentially quite prohibitive for the company giving an indemnity. A termination right's always a key one. Clearly, you don't want to be locked into a contract for too long, because it may well be that it's not what you expect it to be in the future. But normally I'd say something with a bit less than 3 months could potentially be quite awkward to then need to find an appropriate new supplier, for example. Liability cap's another one in that kind of indemnity camp, just to watch out that you're not giving a huge liability cap on any responsibilities that you may well have. Exclusivity, are you required to be exclusive to a customer, particularly to be aware of from a jurisdictional basis to ensure that you're not preventing yourself expanding or doing business in other jurisdictions. Minimum volume commitments are one, as well as just being generally aware of what the governing law is, and in the event that there's any claim, what does that mean? Would you have to contract and sort of make a claim out overseas, for example, which really can be very expensive?
No, I think those are all really important. I think a lot of businesses, as well as looking at their own contracts, that they need to be aware of the regulatory environment that they're doing business in. I think that's increasingly a common issue for innovative businesses, especially in the sort of fintech space, which are, in some cases, breaking new ground, and the existing regulations just aren't drafted to capture what some of these companies are doing, and they can very quickly find themselves in a sort of regulatory tight spot, which sort of, arguably through no fault of their own, could put them in a difficult position with their regulator, which fundamentally threatens their ability to trade.
Absolutely. Thank you very much.
Thank you.